Looking at.
Nope.
Okay, we're live. I was looking at a little spinny thing on my screen, like waiting for this to turn on. Hey everybody, I'm Greg Siskind. I'm back this week for the Siskind Susser weekly live stream, and it's always a different combination of Siskind Susser lawyers. So I will actually, for some reason with StreamYard, which I love StreamYard, and that's what we use to send this out. When you have the banner up, it hides our names because I guess it figures people can't handle that much information in one time. So I'm going to take that off, and now you see who we are. So I'm Greg Siskind. Why don't you all introduce each other? And but I want to start with Marshal Garbus, who is he's not a new lawyer, but he is a new Siskind Susser lawyer. And he is on his first live stream with us tonight. So welcome, Marshal.
Thank you. Thanks for the intro, Greg.
All right. And Adam and Elissa, you can introduce yourselves. Tell a little bit about yourselves. Adam, Marshal, we'll get back to you later. You're going to tell us about what you do.
Sure.
Elissa, do you want to go?
Okay, I'll go first. Hey, everybody. I'm Elissa Taub. I'm a partner in the firm. I head up our firm's healthcare immigration practice. So most of what I do is work with folks in the healthcare world, doctors, nurses, med techs, PTs, you name it. We do it. And then I also do a fair amount of arts, sports, entertainment, immigration as well. And so that's me. I mean, that's the nutshell.
Elissa has an encyclopedic knowledge of sports. Which comes in handy a lot of times for when we're trying to figure out what these clients actually do. So,
yeah.
All right.
Hi, everybody. So I'm Adam Cohen. My practice is largely focused in sort of the intersection of academic and healthcare space. So I do a lot of work with universities, students, exchange visitors, faculty, professors, researchers, clinical trainees, doctors, nurses, PTs, etc. I also do, some family-based immigration as well, and business immigration. So
you didn't mention it. You didn't do your marketing job, and Elissa, you didn't do your marketing job because both of you are authors of books, and you should mention your books. Always plug. So, Elissa, start with you. What's your book?
Well, so my book is the Physician Immigration Handbook. I don't have a copy of it handy, sadly, but it's in its 9th edition. We publish it annually. You probably don't have the new one. Oh yeah, that's last year, but yeah, or the year before.
Wait, I have Adam's book here too, but Adam, so it's not actually yours. Is not here.
Oh,
all right.
Well.
But yes, the Physician Immigration Handbook, everything you'd ever want to know about how physicians immigrate to the United States, maybe even some stuff you didn't know you needed to know.
All right. And Adam.
Mine is the Academic Immigration Handbook. It will definitely come in handy as we're having this conversation about all of the things that are happening in academia. It is now in its 4th edition. I got to start working on the 5th edition soon, and I'm sure I'll have a lot of content to add.
And the thing I like about both of those books is they're really good for both lawyers and for non-lawyers on there. We find that I hear Elissa doggy. But the
yes.
So even if whether you're a lawyer or non-lawyer, if you have a special interest in those topics, those books are good. And if you are a lawyer, you can get it on AILA.org, both of those books. If you're a non-lawyer and you're not part of AILA, you can get them on Amazon, I believe. So there you go. I haven't plugged the books in a while. Marshal, I'm back to you now.
Yeah.
Hi. What's the Marshal story?
Yeah. So I've been with the firm for a little over 2 months now, but I've been practicing immigration since around 2020 or a little further back, going back to law school in the immigration clinic. But my practice recently has been focusing on arts and entertainment, performers, everything in between. I've also been working in business immigration with entrepreneurs and startups, people looking to bring their business to the U.S. Also dabble in family law as well, so have a good background in all the areas of immigration.
So well-rounded.
Yeah.
All right. So we've gotten the intros out of the way. We have we were saying at the beginning, I don't think there was that much this week. And then it was like we started going through it. It's like, yeah, there was like a lot of stuff that happened this week. So we're going to dive a little deeper into a couple of topics that Adam and Elissa want to lead later. Adam's going to talk about this new proposed rule, which we mentioned previously on duration of status, I-94s, and why the administration wants to do away with them. And Elissa is going to talk about a lot of frustrating consular news. It's all frustrating, right? There's nothing good, right?
No, there isn't.
All right, so Elissa will kind of run down that. So, but first we'll talk about, this was a bad week for the Trump administration in court, and it actually, and probably even this evening, like in the evening news, it's like there was, not immigration related, but there was this big case about Harvard that made the news this evening, with the Trump administration basically having to restore about $2.5 billion of research funding for Harvard. We're not talking about that case, but we did have five important decisions. I think there were five. So we'll start with Marshal, and we had, so the Alien Enemies Act. We've talked about this case before. The Alien Enemies Act. Most Americans learn about that in their high school U.S. history class as as sort of one of the first big things that happened, as far anti-immigrant things that happened in the history of the country. I think it was in the Adams administration, and hasn't really been used, the Alien Enemies Act, very much in the last 225 years or so. But the Trump administration has been trying to use it to quickly deport alien enemies, or who they consider alien enemies. So can you give us a little background on like what this case that was determined, I guess, yesterday or the day before, what that decision was all about, which court it was in, and whether I guess we could talk a little bit about sort of where we think that case is going at this point.
Yeah, so this case was decided in the Fifth Circuit against the Trump administration. So it's interesting to note that it comes from one of the more conservative of circuits, coming out against the Trump administration's use of the Alien Enemies Act. But this kind of stems from early March of this year, when the administration was invoking the act to deport, expeditiously individuals, Venezuelan nationals, without any due process rights, under this pretense of an invasion or predatory invasion from the Tren de Aragua, I think I'm saying that right, gang.
It sounds right.
Right. So this case is kind of further along in the process, based on a few individuals who are petitioning their habeas corpus rights while in detention, requesting a hearing for their unlawful detention based on the Alien Enemies Act. Eventually went to Supreme Court, got punted back to the Fifth Circuit, where the court ultimately kind of looked at the statute, when you can invoke the Alien Enemies Act, and kind of determined based on the facts that this is an overbroad use of the act, which is reserved for hostile nations or nations and governments we're at war with, and that this kind of using gangs or expanding this definition of what a government or nation is too broad. So I think one important takeaway is that the opinion was pretty, had a lot of humility, I think, in its decision, and it was kind of suggesting it should go back to the Supreme Court, or the issue should be discussed, by the Supreme Court in another case. So
it is good that this case goes to the Supreme Court from the Fifth Circuit, because I think that a conservative Supreme Court is going to probably consider the source of the decision that it's reviewing, and that will matter. I didn't see sort of like what the combination of judges was in the Fifth Circuit, but that's probably good. The Supreme Court also basically they in the initial decision, they didn't really opine on the issue. They just said that they basically, there had to be at least some due process, even if the Alien Enemies Act applied. There needed to be some habeas rights and that kind of thing. Was that what the Supreme Court? I think that's what the Supreme Court case was earlier on there. So, that seemed like a floor as far as where we are, which is that at least habeas rights attached. And basically, for those who don't know what that means you basically get to have at least a day in court where a person has to at least be brought in front of a judge and make arguments about why they're not deportable or removable under the act on there. So it's going to go back to the Supreme Court, but in the meantime, like what's going to happen between now and then? Right? Is it can they even cite this? Is it basically back to normal detention and removal proceedings and all of that, or is there some? Are they leaving any of this in play while the Supreme Court is eventually going to be looking at it?
Not exactly sure where we're going there.
All right. Well, we can we'll get back on that on there, but I would like to sort of like know what the in the meantime what we're looking at. Let's move to who is talking about the lawyers, the 600 lawyers.
I think you were.
Okay. So there was some news. This is not a case, but it is sort of it is part of the news of the week, and it will involve cases on there. I apologize to you guys for kind of doing this out of order. But there was an announcement from Pete Hegseth, our illustrious defense secretary, who there has been this big problem where I guess that I think I saw the figure that there have been like 1,100 immigration judges that have been disappeared essentially from the courts. I don't know if that was the right number or not, but there's a lot of judges that have been fired. There's a lot of judges who've quit. And there is about 4 million people that are sitting in line waiting for their immigration cases to be heard by judges. So there's a big problem if you want to kind of crank up the deportation machine with the immigration courts, which is that you have to have the courts actually make decisions if people are going to either get relief or get deported. It is a long process to become an immigration judge, although the Department of Justice said this week that they no longer care if you know anything about immigration law. I'm surprised they said they still care if you're even a lawyer. I'm not sure that's a statutory or that's a requirement at all for an immigration judge. It still seems like you have to be a lawyer, but they don't care if you know anything about immigration law, which is a change, and one might say is problematic on there. Although I would like to think that lawyers who are applying for these positions will at least try and learn something about immigration law if they in fact get these positions. But another thing that the administration is doing to try and plug the these huge gaps is to get lawyers from the military. If this sounds familiar about using the military for things that were never intended for the military, this is the latest, but using the military's lawyers to basically fill immigration judge positions. And that is, I'm sure, a big surprise for senior people in the military who probably had no idea that announcement was coming, because that's the way things usually go in this administration. But also, I think it'll be really interesting to kind of see whether this just happens or there are legal challenges. And there was already discussions today that there are regs out there about what military lawyers can do in civilian courts. The regs were mostly written I don't think when they wrote these regs, they even envisioned this as a possibility, that these lawyers could be recruited to actually be judges. But the regs mostly talk about whether they can be lawyers outside of military courts, and when they and what the circumstances are, and it's sort of really closely prescribed, like when a military lawyer can go into a civil court, and what they could do. And so, the administration would have to argue that, well, judges are not lawyers. It's sort of like, if you sort of think the whole point of this regulation was just to really make it restrictive as far as when military lawyers wandered outside of the military courts. It seems like quite the loophole to say that the normal role that you would expect, which is them to act as a lawyer, that's totally off limits. But one that's even more, removed from like their day-to-day duties in military courts, being a judge in a civil court, that somehow was okay and meant when they do those regulations. So that's one issue. And then the other one is, it's like Congress, when they appropriate all this money, there's money, and there's lines in the budget about the using money for the military can use money to hire lawyers for different purposes, and whether sending those lawyers to a different government agency and doing something that has zero to do with the military is actually violating appropriations rules, and whether the administration can do that. I think that's probably the stronger argument, right, is that Congress, you can't just loan lawyers from one agency to another agency on without getting Congress to expressly approve it. So that's what that if you saw this in the news in the last 24 hours, it hasn't happened yet. It's just an announcement that that's what their intentions are. So we'll see if it does get litigated. Of course, we'll talk about it here. So that was that news. All right, Elissa, what do you want? What case do you want to talk about?
I was going to talk about the case with the Guatemalan kids over the weekend. This was it should be shocking. It's not as shocking as maybe it would have been a few months ago, but in the wee hours of the night, I think on Saturday evening this weekend, the Trump administration tried to put a bunch of unaccompanied minors, I think almost 100 of them, from Guatemala onto planes in Texas to remove them from the United States. And they literally were doing this in the middle of the night. They had the kids already loaded onto planes when these heroic lawyers filed an emergency motion to try to get a temporary restraining order. And this judge, and I'm going to mess up her last name, but Judge Sparkle Suknanen, she was the emergency judge on duty over the weekend when this came up. And she really did a hero's job over the weekend of holding the government to account and not giving the government the benefit of the doubt. I think when the men were removed to El Salvador, the Venezuelan men were removed to El Salvador months and months ago, and this case came up before Judge Boasberg, and I think he was sort of treating the government as a judge would normally treat the government when he handled that case. And he was like, we need to have some briefing and we need to have a hearing. And meanwhile, and he said, hey, nobody should be removed while we're dealing with this. And the government found, basically was like, oh, we don't care. And we just want to do this now. And there was a little bit of a window there that the government just weaseled through. In this case, the judge was like, no, I'm not doing that. And she issued a temporary restraining order in the middle of the night over the weekend. It lasts 14 days. And the judge said that, she understood that her order was, quote, extraordinary. But she justified this extraordinary measure because the government decided to, and this is her quote, execute a plan to remove these children in the wee hours of a holiday weekend. And I think, it was such an affront that she was like, I can't let this go. Now, she was the emergency judge on duty. I understand that the judge has now been reassigned to a permanent judge for the case who is a Trump appointee. Judge Signanin is a Biden appointee. That shouldn't matter, but we all know that's not always the case with this administration. So we'll see. The government still wants to remove these children, but for now, they're back. Most of them, I think, or all of them, because the article I was reading is a couple days old, but basically these children are all back in HHS custody now and awaiting, what's going to happen to them next. And I can't imagine for these kids, who are all young kids. These are not like 21-year-old kids. These are, kids between the ages of like 10 and 17. I can't imagine the trauma that they've endured through this whole experience altogether. From being in government custody to being put on a plane, to being taken off a plane, going back. I mean, just the whole experience must have been awful. So anyway, I'm sure that there is much more to come on this case in the coming weeks and months.
Yeah, and the 14 days, that's basically that's a limit for how long a TRO, a temporary restraining order, can last. So I guess she's not on it anymore. You said she's been it's been turned back over to the other judge. Mm-hmm. The next thing they will ask for is a preliminary injunction, which TRO has the highest standard. So it's usually continued in a preliminary injunction as long as whatever the harm is still ongoing. So that's the next thing that they'll probably ask for to get, and that can go for a much longer time than the TRO, which is designed to basically be sort of something interim on an emergency basis until there's time for more consideration on the preliminary injunction. But they essentially do the same thing. So that's probably what will happen. So it could go more than 14 days unless the the judge that's in there now decides to go in a different direction. And that'll be interesting, I think, to see whether there'll be because there have been a number of Trump appointed judges who are not ruling his way. I mean, it's not an automatic.
Right.
My favorite case where we had a Trump judge with the impact cases was the Ukrainian case that we had in Chicago, where we were a little worried at the beginning about our judge, and then he basically made it really clear to the government it was that they were going to have to give work authorizations to automatically to the 150,000 Ukrainians that were being represented in the case. So you never know, and we will see. So I never lose work under the assumption that you can pretty much count on like Justices Alito and Justice Thomas how they're going to vote. But for most judges who not that they don't take their job seriously, but it's a little predictable how they're going to go after all this time. But for a lot of judges, whether they are appointed by a Democratic president or a Republican president, if they take their jobs really seriously, and I think most of them do, if you've got the arguments, you have a shot, even with the most conservative judges or the most liberal judges. Okay. Has anybody talked about Gavin Newsom's big win? Newsom versus Trump?
Not yet.
Okay. Well, I can mention something about that, but we were chatting about that. We'll talk about that as a group. So Newsom versus Trump, it's not really Gavin Newsom going up against Trump, but he's the governor of California. So he plays a role here. But there was a big decision that the Trump administration is going to have some problems with. You may remember that he nationalized National Guard troops in Southern California, basically to team up with ICE and help with immigration enforcement and also suppressing peaceful protests and all kinds of other fun things. And that got litigated with the state of California, basically saying, you're not allowed to do that unless we ask you for your help. This is and so this case got litigated. It kind of has gone up and down on there, but basically, I guess the early decision went against the administration, and then the appeals court basically kind of let things stay in place for a while, and it went back and sent it back to the lower court, which just issued a decision on the substance, some of the substantive issues in the case. One of them is I love the name of this, the posse comitatus. Is that Latin or is that okay? That's Latin.
I think so. It sounds Latin.
Sounds like the Old West, the posse. So the Posse Comitatus Act, which was passed a zillion years ago. It's not quite as old as the Alien Enemies Act, but it's like, I'm pretty sure it's 19th century. That law says that it really restricts how the military can be used for domestic, as part of domestic law enforcement or purposes. I think it had something to do with union busting, but I'm not quite sure on there. I don't want to, don't hold me to that on there. Go ask ChatGPT, it'll tell you. But the Posse Comitatus Act was the reason essentially why the court said you can't use the National Guard or the military to basically help you with your immigration enforcement, interior immigration enforcement. They might have some more room to maneuver around the border. The Trump administration, there is an exception to the PCA, the Posse Comitatus Act, which allows for military involvement in domestic affairs, but it's very narrow conditions. So that would be if a state, for example, asked for assistance. And obviously, this is Newsom versus Trump. Gavin Newsom, the governor of California, is suing Trump. So in this particular case, the state of California said, do not do this. You can do it when there's apparently when there's a significant obstruction to law enforcement. I'm not quite sure what that means, but the court said the Insurrection Act, which is what the Trump administration is trying to cite, that doesn't apply, or when constitutional rights are being violated and state authorities are unable or unwilling to act. And that was definitely not, it was like the opposite, where they were coming in. The ICE is actually probably doing all the violating of the constitutional rights versus protecting constitutional rights. So the court said that the administration's sort of workaround, the Insurrection Act, doesn't work for them here. Now, what's going to be interesting is as soon as this decision gets announced, Trump goes on TV and says, yeah, we're still sending everybody to Chicago and Baltimore, which I guess are the next two on the list. And the governor of Illinois is already basically, gone on the offensive to say, don't do this. We're taking you to court. We're not going to allow this to happen without a fight. So my guess is that lawsuit is essentially already written. And the moment the first federal troop steps foot in the city of Chicago, the Northern District of Illinois is going to have a suit filed.
And the Texas National Guard, they already have or they are deploying them to a base just north of Chicago to mobilize from there. So they've already taken the Texas National Guard, which has not been federalized because they don't have the basis. There's no legal basis for Trump to federalize the Texas National Guard. Greg Abbott has just basically said, yeah, take my people. What could happen in September in Texas where we would need the National Guard? Like, we don't get hurricanes or anything. And so he's basically said, take my National Guard troops and amass them outside of Chicago. Because
are they already there, or has he just said that could happen?
I think they're in the process of moving them to a base just outside of Illinois, on Lake Michigan somewhere, and that's a very serious matter. Like, aside from the courtroom gamesmanship and all of this, just thinking about one state sending its National Guard to threaten another state's sovereignty under our system is something that is really never supposed to happen.
Yeah, so look for the Illinois Attorney General probably to be filing something shortly in the Northern District. It sounds like they may already be in a position to do that. and it's not premature. But that's going to happen. And Westmore in Maryland, I'm sure, is going to do the exact same thing in Maryland as soon as something happens in Baltimore. And we also, I guess, the military has been involved with assisting ICE in the District of Columbia, and there's a case in DC also. I'm not really sure where they are, and also it can't be that far away from the 30 days that they have, I guess, where they get basically free. They're free to do anything they want. The federal government on there. So it's not really clear right now whether DC that can go on, how long that's going to go on for. Although DC is very different than the states because they are, it's a federal city, so they have they're under a lot more control from the federal government than the states are.
In DC, my understanding is that the deployment, the federalization there could last for 30 days. And in advance of those 30 days, just yesterday, Mayor Bowser basically says, yeah, they can stay as long as they want. We'll cooperate. I'm instructing our local police to cooperate with the federal folks for as long as they need to. And she was basically like, I need to do this in order for things to not escalate further. So I'm not really sure what's happening behind the scenes there, but I was kind of surprised about that. But the dynamic in DC is very different than it is in any other place in the United States. So,
yeah. All right. Were there other cases? I'm trying to remember before we get on to the other news. But I thought there was another one.
I crossed off everything on my list. There might have been another one, but I can't remember what it was now.
All right. Well, we'll move on. All right. So, Adam, let's talk about. I'm going to let Elissa do cleanup on the consular stuff. Adam, tell us about about this proposed rule. First of all, kind of give a little background on the administrative process, sort of on like what's happened up to this point, how this thing actually could move to becoming a final rule, and then maybe a little bit of background on Trump administration, the first Trump administration, where they tried to do some action in this particular space unsuccessfully, and why this might be different or might be the same. So give us a little background on what this is all about and why we should care.
Well, I guess I'll start too, and I'm sorry I don't have a lot of great news to report, but I've had my head stuck in a 116-page regulation for a while. Basically just the nutshell, so everyone understands, and then we can kind of talk about the nuts and bolts in the process from here. Is this attempt by the government, it's their second attempt. They did it the first, as you mentioned, Greg, the first Trump administration, is to remove this period of authorized stay for F students, J exchange visitors, and also, we won't talk about it as much, but journalists with an I status. That's very important. There may be some that are affected as well, some that may be tuning in that are affected. And basically, this period of authorized stay, it's this duration of status, it's been around the history for F students and for J exchange visitors since the early 90s, that a decision was made to not authorize them for admission for a particular date certain, like we see with almost all other non-immigrant statuses, but rather to give them this more, I guess you could say, a more flexible period of authorized stay, as long as they're making normal progress toward their educational or their research goals. And we can talk about the reasoning behind that and what's so important about that. But it is very important, and essentially the idea would be to limit them to this period that could be no greater at a particular time as 4 years. Okay, so it could be less depending on the document that they have, their I-20 or their DS 2019, that regulates their current program end date. So it could be a lot shorter, but maximum could be 4 years. And then basically it will become systematized that they have to file these extensions of stay with the government. The government becomes sort of assuming the place that is filled by essentially by, deans, departments, international student and scholar services offices who evaluate educational goals, extending program, program end dates, etc. And it's now becoming, bureaucratized basically with these series of extensions of stay. So essentially, it's in a proposed rule format at this point. It has already gone through the Office of Management and Budget. Now is the time to issue comments. The government only provided 30 days. I'm pretty sure they do. They often have longer periods than this.
Oh,
But they only gave 30 days. The comments are due on September 29th. And this is a very meaty rule, as I was mentioning. It's like 30 pages of regulations themselves. And there's 120 pages of preamble, 130 pages of preamble, and additional commentary. So it's really a lot to wrap your head around, and it completely upends a lot in the immigration dynamics of students and exchange visitors. So it's a lot to process and to turn into a comment in a relatively short period of time. And Greg will put up for us how to do that commentary, but where to go to comment. But basically, it's very important to provide comments. There's an opportunity. This is the opportunity to provide meaningful response. There has to be meaningful consideration by the government. We'll see what that will look like, and then ultimately a final rule will be produced. But
can I sort of ask you a little bit mechanically, like what happens? So so basically the school would issue, let's say it is a student, the school would issue an I-20 that would cover, I guess, the next school year, maybe, or the next degree period. I mean, and then the student would have to file an I-539 every time the I-20 is set to expire, or like basically what would the process look like after this rule goes into effect, as far as how students will now get extensions and what their I-94s are going to look like?
Right. So, I mean, first off, there's going to be this transition period, right, for the students that are currently present in the U.S. And they have this duration of status end date. It's going to end up being converted into a limit that's basically aligned with their program end date for their current I-20 or for their DS 2019. And there's other idiosyncrasies related to OPT and to STEM OPT. We don't have to get into all the technicalities, but basically, if that they're going to get a maximum period that's going to be no greater than 4 years, and it could be a lot less depending on their I-20 and their DS 2019 and what that says, right? And then from there, they're going to need to extend for, if their program is not going to be completed within 4 years. And that's also going to happen for those who depart and re-enter, for brand new students coming in, right? And degrees can oftentimes be longer than 4 years, and students may, there could be various, even progressing to master's degrees, progressing to PhDs, getting practical training like, OPT and then STEM OPT thereafter. Maybe they can't complete their course. Maybe they're a few credits shy, and they need a little bit of additional time to complete their course of study. All of this is going to be evaluated now by USCIS, every type of filing. And in certain cases, it's not entirely clear from the regulations, but in certain cases, there will need to be a showing of compelling reasons to justify that. And they give some examples, but there's going to be a lot that's going to be left to the discretion of the officer. And that is very much woven into the regulation itself, this determination of discretion. So it's one of these things where, I want to make sure I'm kind of hitting the main highlights. Part of the rationale, I think it's important to point out, right, that they're using for this is that they're saying there's a high number of international students who overstay. They say there's a large volume of F&J, visa holders, and that they cannot monitor, they're concerned about the ability to monitor these individuals. Okay. There's only, of those three things, only one thing is true. There are a lot of F students and there are a lot of J exchange visitors. It's not difficult to monitor them. That is all done through.
That's what CVIS was.
Exactly.
CVIS was that they're putting all this information so the government knows exactly what they're up to and that they're progressing along.
Absolutely, and we shouldn't discount that universities receive SEVP accreditation to issue I-20s. They receive accreditation in research programs, et cetera. Private organizations receive accreditations from Department of State to sponsor J1s, right? That's all done. And then there's an additional vetting element for your F students, for your exchange designated school officials who issue the I-20s, responsible officers who issue the DS 2019s. There's an extensive vetting process for them. And there is a vetting process for students and exchange visitors as well, right? That's through Department of State, that's through USCIS itself, because there's a lot of, they pass through USCIS very often too. It's not like that USCIS never touches their files or their cases, right? Changes of status, reinstatements, OPT, STEM OPT, right? All of those things pass through USCIS. And the whole issue of the overstay aspect, it's based on flawed data. I think we've seen this time and again, right? A lot of these issues, the data at ports of entry, especially at borders, it's not always very solid information. And so there's a lot of holes in it. And it's like, if there are certain minor issues and problems, right, when we're talking about like millions of students, right, you don't have to necessarily upend and bureaucratize this entire thing, right? The entire duration of status, period of authorized stay. There could be other less invasive ways to handle this, right? But it's really just this very broad brush, bull in a china shop approach. And this is kind of what we get. And the lasting effects to it, so it's removing flexibility for the students in their courses of study in a lot of different ways. It's limiting, graduate students cannot change their programs at all. Undergrad students, they have to wait for the first 12 months before they're actually able to change. There's things of that sort, those types of restrictions, but it's also just taking, it's taking this authority away from highly skilled professional DSOs and RSOs who now they have to do everything that they always did in CVIS, but now they also have to, assist students in the filing and provide guidance in the filing of these extensions of stay. It's completely redundant and unnecessary process, huge overreach. It will be it will add, basically flood these offices, add all of these added costs of training. And let's not forget these downstream effects that it's going to have on USCIS, right? We know USCIS.
Does the approval have to actually happen before the person can continue on, or is it sort of like you just have to have it filed?
Yeah, that's a really, really important question. So for F students, they are, as long as it's timely filed, which is, either a filing during the program of study or within the 30-day grace period, because they're shortening 60 to 30 days, the student can continue going to school. However, the filing during the course of study, right, itself, for CPT, for on-campus employment, for severe economic hardship, for special student relief, all of these other types of work-based benefits, some of them based on need, some of them based on issues in their own home country and disasters and things of that sort, they get 240 days of extension. And we know how long extensions of stay are taking, like, let's say in the H-1B context, 6, 7, 8 months or so, or more. And so it's a 240-day extension if the extension is filed during the 30-day grace period. There will be no continuation of work authorization until the extension and until the extension and in certain cases the EAD are approved. In the J context, they are able to have a 240-day extension of their ability to participate in the exchange visitor program. So it's even a worse situation because they might have to, if those extensions take longer than 240 days, it's going to disrupt their ability to continue in their program, right?
Yeah,
Their research scholar program, their clinical training.
That's what I was thinking of, or the doctors that are in residency programs, because they get DS 2019s typically for a year at a time. In their programs, I believe that PGY 1 year, they get a DS 2019 for that, and they have one for each. They have them. So we know that 240 days is going to be, if you give USCIS 240 days, we're going to see lots of examples of 270 days, 300 days, where they're going, and there's not going to be, and we don't have any sense that there's going to be premium processing or anything like that available here.
No. I mean, I don't think that we can assume that that'll be the case, right? Like you have premium processing currently for changes of status to F and changes of status to J. And I think for work authorization, if I'm not mistaken, for OPT work authorization, but I would not assume it's going to be available in this context. And I think if we're looking at this all super big picture, right? What are the downstream effects of adding in thousands of extensions of stay to USCIS workload, right? Not just for
they're losing workforce right now.
Right.
They have fewer people to work with than they did before.
Greg, I just wanted to mention also for doctors, most doctors initially are going to do a 3-year residency. Most doctors are going to finish their internal medicine residency within the allotted 4 years. But I think where the real concern comes in for them is with fellowships, doctors who want to engage in specialty training, because they might do a 1-year fellowship and that would get them to the 4 years, right? They could do a geriatrics fellowship or something like that, just a year. Okay, fine. But if you want to do anything more than that, that means that they're having to extend their stay mid-fellowship. And one concern of a lot of GME programs is when they admit a fellow to a fellowship is whether they will be able to finish it given the allotment of stay that they have. I've seen this come up where physicians need an 8th year of J time, and it's unclear whether they're going to be able to get it. We've seen it with some programs that don't even want to accept residents or fellows who have H4 EADs because they're afraid that status isn't going to carry them through the whole program. And if they're allotting that precious residency or fellowship slot to this physician, they want to know that they're not going to lose that participant halfway through the program. And so I think this is really going to hurt international physicians' ability to complete fellowship training in the United States. Even if USCIS expertly and deftly approves those extensions of stay in the right amount of time, the fear on the part of the fellowship programs in admitting those folks to the fellowship because they're afraid they're not going to finish it, I think it's going to have a real chilling effect on our supply of specialist physicians.
Yeah, and I think that's, some of the strongest arguments probably to be made are actually on the healthcare side of things, because the students have been coming under constant attack from the administration, but they've been usually pretty careful about attacks that they're making on physicians. Particularly, I think there's some sensitivity right now about rural healthcare and a closure of rural hospitals because of the Medicare Act. And there's a lot of sensitivity right now to the supply of doctors in the U.S. and access to that. And a lot of these doctors that are in residency programs, a lot of these residency programs have outreach to rural clinics and to rural parts of states. Oftentimes, academic medical centers, which are doing the training, are sort of the one place that people from big rural areas can go to for specialty treatment. So hopefully our friends that are in the medical community are thinking about this and will issue comments. I'm guessing, Elissa, the IMG task force will, but I'd also like to see there's a union that represents residents and fellows that usually cares about this kind of stuff. Hopefully they will weigh in. Hopefully some of the organizations that are involved in academic medical training will weigh in.
You would hope ACGME would have an interest in commenting here.
Yeah, no. So going back, so at the beginning, I mentioned that this came up in the first Trump administration, and this is a little bit different. It's essentially doing the same thing. My recollection was that in that first pass which they did by memo, which is important, that they cited security issues as sort of the big reason behind it, whereas this time they're citing more in line of like just immigration violators. Overstays, fraudulent, people on there is sort of the basis for. So they changed their rationale a little bit from this time to last time. But procedurally, what's going on this time that's different than the last time?
Well, so I think there were two things that were going on last Trump administration. So I think it was 2018, there was an unlawful presence memo. And I think it's been sort of confused with the regulation that did come out, because that was the one that people saw that gained sort of the most traction and was ultimately shot down by the courts, because they were issuing a law, essentially a new rule out of a memo. And that was a situation where they were going to say, if you violate you have any type of violation, which they weren't even defining, that would immediately result in accrual of unlawful presence and all of these,
so they never got to this issue the last time.
So that memo got shot down, and then they had a regulation that was rather similar to this regulation, but I think that one ended up dying out because it was late. It was late in the first Trump administration, and that ended up not ultimately going through. Now they're doing it, early, but it's rather similar in that sense.
Okay. All right, so it wasn't really tested the last time.
No, not this regulation. No. The memo was tested. Yeah.
All right, so people screenshot or take a picture with your phone of this address, or just write it down. It's not that long on there. And please, please, please talk to your organizations about writing comments on this. You don't have very much time to do it. I am sure there are some good model comments that are out there. I'm sure that that as well, that if you your immigration lawyers who help your organizations will give you guidance as far as like how this works, or maybe even work with you to write the comments. So please consider doing it if you are a university or a healthcare organization or anybody who relies on F's and J's. Students and exchange visitors are welcome to write comments, but I think they'll definitely get more consideration if they come from organizations and U.S. citizens. All right, Elissa, I'm taking this off the screen. Bring us home with talking to us about what's happening at consulates.
Okay, woohoo. All right, so the first thing I want to say, which we didn't talk about in our pre-meeting, but I just want to remind folks, as of yesterday, that's when the non-immigrant visa interview policy went into effect. So now pretty much everybody who applies for a non-immigrant visa at a U.S. embassy or consulate needs an in-person interview. That's H's, L's, O's, P's, Q's, R's, everything. Everybody needs an interview, even if it's a renewal. There are very limited exceptions for B visas, and we're even talking about like babies and old people. So keep in mind that went into effect yesterday. All right. So new stuff. Last week, August 28th, the State Department published a new policy with regard to immigrant visa processing at consular posts abroad. So this is people who apply for a green card from outside the United States, and they have to go for an interview at a U.S. embassy or consulate in order to get the green card. There is a process that is managed by a sub-agency of the State Department called the National Visa Center, which is based up in Portsmouth, New Hampshire. It's a lovely little town. I've been there a few times. I really like going to visit. And the National Visa Center is the keeper of all of the applications that people file when it's basically the equivalent of an adjustment of status application. It's just being filed through the State Department. And then the National Visa Center assigns that case to the relevant consular post and arranges for the interview and all of that. In the past, if let's say you were living in London maybe you're not a UK citizen, maybe you're a citizen of India, but you're living in London, and you file your DS-260 application and you're assigned to process your immigrant visa in London, and then you get transferred or you move to Vienna. You could contact the NVC and say, you know what, I'm not in London anymore. I want to process in Vienna. I am authorized to be in Vienna. I've got an address there and everything, in the NVC would check with Vienna and say, okay, we're going to, we'll move your case over to Vienna. As of November 1st this year, that's not going to be possible anymore. As of November 1st, the State Department is requiring immigrant visa applicants to interview in the consular district of their that is designated for their place of residence, or if you request it, your country of nationality. So in this case, in the example I gave, the person could either process in London because that's where they were residing at the time, or they could process in India, but they're not really going to entertain any other post transfers unless there's some kind of real emergency, some humanitarian, circumstance, or like really, really big issue. So this is a really big deal. They're not going to be doing any elective post switches anymore. Oh, well, it'll be more convenient to process here or there or wherever. That's not really in the cards. There are some countries where there are not regular consular operations for the U.S. government. And in those cases, the State Department has now officially designated alternate posts for those folks. The one that really comes to mind for me is Haiti. There wasn't a specific alternate post designated for Haiti previously, to my knowledge, but now they are designated for Nassau, the Bahamas. Afghanistan has been designated for Islamabad. Just giving some, just cherry picking a few examples. Syria, Syrians can go to Amman, Jordan, Beirut, Lebanon, and like Venezuelans can go to Bogota and things like that. So there are some alternate posts that that those people will automatically be designated for those posts. They don't have to make a request. But outside of that, the State Department is expecting folks to process in their most obvious posts, I suppose.
The ones that you just gave, are those where they just don't have immigrant visa processing operations there, so it's not really sort of doing a favor for people in that country. It's just there are no U.S. consular officers there in those countries to do the work.
Correct. And, for folks, they have to get to the other posts, right? So that's not always so easy. And there are sometimes entry issues where, like, I think for a while they couldn't designate, for example, it would be the easiest thing to designate Santiago Dominican Republic, Santo Domingo. Oh my gosh, I can't believe I did that, for Haitians, but the Dominican Republic doesn't
want Haitians. Yeah.
So they're designating Nassau. So then the Haitian folks, they have to get to Nassau, which isn't the easiest thing for them to do. It's hard to leave the island in the first place. So yeah, but this is being done because they need to provide some alternative. And I will say, for the Haitians, for a while now, there's been a lot of clamoring for an alternate post, and the State Department was very reluctant to provide that. And so finally with this, there is one.
Do they pick these places because these countries will give entry to the national? So do Haitians have a hard time getting into the Bahamas?
I don't know. And so to give you an example, for Russians, the designated alternate post is Warsaw, but they can't get Schengen visas.
Right.
And so IR5s, parents of U.S. citizens, they can go to Almaty or Tashkent. And that's been the case for a while now. But everybody else gets designated for Warsaw, and then they can't get there. So there has been a huge outcry for Russians to be able to process anywhere else. And the NVC has been incredibly difficult to communicate with on getting Russians designated somewhere other than Warsaw. And on the list I'm looking at right now with this announcement, Russia is still designated for Warsaw, with the exception of the IR5s. So, right, we're not doing the Russian folks any favors in trying to help them apply for green cards from outside the United States, because they have to be able to get into Poland. And so that's a big issue. So no, I mean, this is an issue of some U.S. diplomatic ties and, what our own embassy staff can withstand in those places if there's an increase, in demand for interviews and things like that. But I don't know. This isn't like people being guaranteed entry into the alternate port country. I don't think that's part of the deal.
So that's frustrating. How
Yes.
about, is there any other consular announcements for today?
Well, actually, one other thing I wanted to mention, and this dovetails with two other just real quick things. The Palestinian non-immigrant visa issues. Just the other day, there were a bunch of news reports. I think it may have been yesterday, the day before, a bunch of news reports that there was a recent cable, I think on August 18th, the State Department sent a cable out to its consular posts to issue 221G refusals to every applicant who appeared that had a Palestinian Authority passport. If the person has dual nationality so that they also have some other country's passport, then they may be able to still process and get here on a non-immigrant visa. But if they only have a Palestinian Authority passport, they are going to be issued a 221G refusal, and it's unclear whether that'll be able to be overcome. And if they're a dual national, then they're not completely out of the woods, because the State Department still says that they're going to be looking at individual ties to the PLO or the Palestinian Authority more directly. One of the things that's very troubling about this is that this was done by cable. This was not done by presidential memo. This was not done by Foreign Affairs Manual update. And this was reported out in the press because apparently the cable was leaked, not because the State Department was like, oh, hey, we've got this new visa policy for Palestinians. And so this is like the next thing I wanted to mention. This is part of a trend I'm noticing with regard to State Department policy, that they are doing a lot of policy changes. For example, when they started the social media vetting for FM and J applicants, they announced publicly that they were going to do it, but the parameters of that and how deep and widespread those reviews were going to be, that was done by cable. And the State Department has every right to communicate with its consular posts by cable. I'm not criticizing that necessarily, but they're also not corresponding, they're not issuing enough corresponding public statements about this stuff for us to be able to adequately prepare folks. So, for example, with this Palestinian non-immigrant visa ban, essentially, this wasn't a 212F ban that the president issued, right? This is like, hey, 221G these people because we think that there are national security issues here. And so that's very troubling to me that was kind of done in secret and not necessarily out in the public for everybody to see. It's becoming increasingly clear to me, especially with their statement with the State Department's statement that they're going to be doing this continuous vetting of visas, and they can revoke someone's visa at any time without warning, and all of these things, that it's getting increasingly treacherous to consular process. And that doesn't mean that people can't travel, but they need to understand that there may be new risks to travel that didn't exist before, especially when it comes to navigating like the visa world. And then the last thing I just wanted to mention is on consular processing is that the State Department months ago laid off 250 foreign service officers, many of whom were consular officers. And just this week, we learned that they've now hired about 100 new ones that are going to start their training process toward the end of this month. And that seems like good news, because more foreign service officers, maybe more consular officers, increases maybe some interview capacity. But you also have to think about the folks who are accepting jobs with the State Department right now, and who have been vetted by this State Department as particularly in lockstep with their priorities and policies and positions on things. And that's of concern, because we don't know how,
we still think they had to pass the Foreign Service exam, though.
Oh, it's not that they might not be smart.
I mean, that's at least something where it's like not completely unqualified.
No, it's not that they're not qualified. It's that they may be coming at this with an ideological perspective that we're not used to seeing with consular officers, because the Trump administration is very clear about how they view immigrants.
Well, they're not supposed to be. You're not supposed to be able to figure out what their ideology is. They're just basically supposed to administer.
Right. But this administration has made it. But the administration has made it clear that they don't want people working for them who don't believe in everything they believe. So if they just hired 100 new foreign service officers, that's a little bit of a concern. But that's all I've got on State Department.
We do have a question, or a questioner who had a two-part question. So one of them was, the first part of it was, if the student's out of the country, can they complete credits, say 30 hours? But I think the second question was maybe a little bit more clear. for a student who's on an F1, can they complete their credits online outside the U.S.? I can probably address that, even Adam. You don't have to on there, which is the U.S. cannot regulate you when you are outside the country as far as the U.S. immigration rules don't apply when you're not here. They can apply when you try and come back in. But if you're just finishing up a degree program online outside the United States, it's not really up to U.S. immigration authorities to have any say in completing it online outside the United States. All they can do is regulate what you do when you're physically trying to come into the United States and you are actually in the United States. Do you agree or disagree, Adam?
No, agree. And I would add also that, with everything that Elissa was talking about, with all of the vetting and everything that's so difficult, especially for students with Department of State and visa issuance, universities are having to rethink models and what's possible from outside the U.S., what's possible maybe in other partner universities outside the U.S. as well, not just online. But yeah, a lot of that is happening.
Okay, so I think we addressed that, and we will call it an evening. We're 66 minutes in. So I, on behalf of Siskind Susser, thank you for watching. Quite a few of you are here tonight. And we will be back next week, but I don't know what combination of people. We'll find that out in the next couple of days. But I like having this subject matter experts here. Marshall, we'll have you back, and I want to kind of dive deep in with you, and maybe Elissa will join on the entertainment and sports stuff. Perfect. Because I don't think we've done much on this weekly live stream, kind of doing a deep dive on that particular subject. So thank you. Hopefully that this first time on was not too traumatic on there, and we'll see you all next week. So thanks, everybody.
Thanks, everyone.